Welcome back to the Law Unscripted, where we talk about the law, all things about the law and the legal system.
Yes.
That you never knew.
Never understood.
And no one ever told you.
I'm Chelsey Rogers.
And I'm Virginia Tehrani, and we are with Tehrani Law, LLC, because you never need a lawyer.
Till you do.
Okay. Tell the topic before it gets too far.
We are going to talk about murder.
Yes. Wahaha. Today is the murder episode.
Yes. Or as we call it in the law, homicide. I'm sorry.
Yeah, that's so funny. And it's true, as most of the attorneys and the law students, it's homicide.
Yes. I mean, and it's really death, because we'll talk about sort of like manslaughter, which is not murder, right? Like, it's different.
That is very true. And apologies on the microphones today. We're struggling a little today.
We decided to be strong, independent women who can set up their own set, only to realize that perhaps, not for sure, we might have needed some assistance.
Perhaps my husband was useful after all in working on all the equipment.
But hey,
not that we had to have him, mind you, just in case he's listening, but he might have been of help.
Yes. I think we did okay, though. Let us know in the comments, but I think you can hear us, you can see us.
At least well enough.
Yeah, at least well enough.
Anyway, so murder, death, destruction.
Yes.
Puppies. We have puppies. I am pretty sure you can see at least one of our puppies very clearly in the video. I have Willow, who is sitting on me.
Yes.
On the couch. She loves soft stuff. That's what we call it. So anything that is soft, any blankets, pillows, whatever. And so today she has decided that the little pink blanket that is on me means she should also be on the pink blanket on me. Charlie's beside me. You may or may not be able to see him based on our camera angles, but he's the other Cocker Spaniel. And Sky is scooched up next against him, but I don't think she's in the picture at all.
Yes, I have the view, and I'm so jealous of all three dogs curled up so cute on top of Virginia. But maybe I'll get one to come to my side eventually.
Maybe. Charlie does love you a lot.
He's a very sweet boy. Okay, so Virginia.
Yes.
Murder.
Death. Most foul.
Yes. So I think anybody who's seen at least one episode of Law and Order or Criminal Minds or How to Get Away with Murder, which is one of my favorites. It's like a bizarre take on law school. They're like a criminal law professor has like 4 students that, spoiler alert, came out years ago, but kill her husband, and then she helps them get away with it. But as the seasons go, they're just racking up a body count like no other.
Wow. I never watched it.
It is truly absurd. Like maybe one episode would be like accurate to law school. After that, like it's not, because when our first years in clinic, like there's a lot of things that just don't quite add up, but it's worth the watch. I would say I've watched it over and again a couple times.
I don't know that I can, because I've been to law school. I've now been practicing for 17 years. I've done prosecutions for murder.
Yes.
I've done criminal defense, and I get so angry just with Law and Order that I don't think I could watch that show, because I start yelling at the TV that I'm like, you can't do that. You can't do that. You cannot do that in a real court.
See?
And it just doesn't happen.
I get so excited at this point because I recognize you can't do that, right? I'm like, I do know the answer to this. Actually, like I'm still at that point. So when I see the inaccuracies, I'm like, I actually know the real thing. I might get Charlie.
Charlie moved.
Oh, sweet boy.
Oh, and Sky has scooched over this way.
Perfect.
Oh, Charlie.
But no, what I was saying is that anybody who has seen any of these shows has heard first-degree murder, second-degree murder. Mm-hmm. Maybe. I don't think I've ever heard that on a show, but third degree. What does that mean?
Yeah, so there definitely is a difference. Okay. And there's the standard difference. And this, I think will be more interesting for most of our viewers and listeners.
Yeah.
And honestly, with the episode that we're doing is the week, I guess about 2 weeks after now the video has come in or out for the Tyre Nichols case.
Yes, and the charges were pressed maybe last week or the week before when this comes out. And sort of in our weekly wine and that week, we talked about what the officers were charged with, what they possibly could have been charged with.
Yeah.
But it kind of inspired us that it does get confusing. And here's the thing about the law. It's not like it depends. It's such an obnoxious answer, but every state is different in how they approach even like first degree is kind of first degree everywhere, but sort of like what the statutory requirements or elements are going to vary a lot state to state.
They really do. And there's the standard answers. So when you're in law school, you're taught, you're basically given a little flow chart of here's first degree down to second degree, and that you start at the top and then you go down to 4. First degree, second degree, voluntary manslaughter, and involuntary manslaughter. Those are the ways that you're taught. And then there's like this little line to put 2 at the top and 2 at the bottom. So the top 2 are first and second, and then there's the manslaughter group together, and then a couple others sprinkled around. But in reality, most states have similar rules, but like you're saying, even state to state, they differ. And we're going to pull out some of that. There's a difference in Virginia code versus Tennessee code, which is what the officers have been charged with in the Tyre Nichols case, where they've been charged with second-degree murder. And we're going to take a look at that and what could they have been charged with.
Absolutely.
And then the difference there between Tennessee's first and second-degree murder versus Virginia's felony murder case or charges.
Yeah. So, and I think the way they did it in law school for us too is like generally when you're doing a hypo, start at second degree and you're probably going to go up or down, right? Because second degree is, I think the example you use, I think it's great, is that like I walk in and see my, spouse with their lover and I have a handgun and I fire it and I shoot it. That's probably second degree murder.
Yeah. Isn't there that, it's such a guilty pleasure of mine. There's the old Maroon 5 song about that. You remember? And it's like, I had to shoot him dead.
Yes.
The
oh my gosh, what is
in
this
that,
song? No, you're exactly right.
Wake up call. Wake up call. Caught you in the morning with another one in my bed.
Yeah.
I never sing, and the fact that I'm singing on camera is ridiculous. But yeah, with another one in my bed.
Yes.
So I had to shoot him dead.
Right.
He won't come around here anymore.
I would hope not.
But yeah, that's the classic, here's second degree. Heat of passion. Crime of passion.
Crime of passion. That's the thing. Heat of the moment type.
You meant to kill him. And that's the top part. So the first and second are kind of clumped together because it is an intentional act. You are trying intentionally, purposefully to kill somebody.
Yes.
So the second degree is like, oh, you sure meant to do it, but it's in that heat of the moment. It is that crime of passion. You get so emotionally wrapped up into it that there's just a little bit lesser of... criminality isn't the right word to say it, but
culpability,
maybe? Yeah, where they're still saying this is really bad.
Yes.
You shouldn't do this. No. This is really bad. But we're not going to say that it's first degree, because first degree, you think of...
like premeditated, you lying in wait. Like you think those are the like scary, like the serial killers. That is the premeditated.
That's how we think of it normally. And that's how, the law shows and movies is the murder in the first is one of them you not only do you intentionally and purposefully do it, but you plan it.
Yes.
You set out to make it happen. You don't just find someone in the bed. You go and wait for them to get in the bed.
Yes. You found out about the affair 4 months ago. And you waited.
Yeah. So that's the idea of the difference of first degree is just that extra planning, is that extra time of extra culpability of not only did you choose to make them dead, did you want it to happen and you did everything to make it happen, but you really went out of your way to do it. In general. Just in general.
Yes, this is super general, but it's sort of the guilty mind, the intent. When you think about someone who did something like, I wanted to kill them, you're in there.
Yeah, you're in the first and second degree.
And when you get lower than that, it gets real complicated.
It does. It's not as easy to understand the lowers. the general idea that they tell you in law school and that you can think of in most cases, most states, is there's the malice crime. So there's
malice aforethought. Oh my God.
Malice aforethought.
Where did that come
there
from?
You
Look.
go. Law school. Malice aforethought is the fancy language a lot of states use. There is thinking involved.
Yes.
It's done maliciously, with intent. Once you go below that line into the manslaughter charges, generally you have voluntary manslaughter,
Right.
And involuntary manslaughter. It is hard to know the difference, and even I get tripped up on it.
Me too.
Because you're intending on voluntary manslaughter. Generally, you're intending to at least cause them serious, grievous injury.
Right.
And they happen to die at your hand of it.
Right. Like you get into a bar fight. And I don't think anybody who's getting into a bar fight is like, I'm going to kill this person. But if you're fighting and you grab a beer bottle in the midst of a fight and you kill somebody, your intent kind of was formed there. Like
you still had intent.
Yeah.
Right. And in a way, what you can say is you did something that if you do it, you should have known that it could or would cause their death.
Right.
If you're using a baseball bat to beat someone, well, it's pretty reasonable to assume that if you continue to use that baseball bat, that they are going to die.
Absolutely.
So maybe you didn't set out in your mind specifically to go kill that person. But if you are in a fight and you pick up a baseball bat and use it, then it's such gross wanton disregard, reckless disregard for another human being's life that the only, one of the main things that can happen is either serious bodily injury or death.
Yeah.
That this is the natural flow of things, so to speak. The voluntary is, it's not malicious.
Right.
But it could be intentional.
Right.
And then the involuntary is where you didn't necessarily even mean to harm someone.
Right.
But your actions are so reckless.
So egregious that you're responsible.
Right. And like you were saying before, not on this podcast, but on the weekly wine that we just did, based on Tyre Nichols, is a lot of times this idea is the vehicular homicide.
Absolutely. I think that, to me, that's the one that makes a lot of sense. Just when you're, obviously these are very general, but you're like, okay, this person got in their car, they were drinking and driving, they drove, they did all of those things intentionally. But their intent when they were doing that was never to harm anyone in any way. But it is so egregious that it's like, what did you think was going to happen?
Yeah. The law makes you responsible for the death. It makes it murder or manslaughter. It makes it a homicide. It makes it manslaughter. So you are still criminally responsible for their death, but you didn't get into your car trying to kill somebody.
Exactly.
You didn't get into your car even wanting to hurt somebody. You got into your car just wanting to drive home normally, right?
Right.
But you got in knowing that you'd been drinking and that one of the natural consequences, it's so reckless.
Yeah.
It's such a disregard of other people's lives that you should have known better. And we're going to make this a homicide.
Yes.
So that's the very basics.
That's the very basics. And I think we covered a lot fast.
We did.
But I think there's a lot there. But I think that's a good summary, right? Like you start with the most serious, and that's that you thought it out beforehand. You made a plan. You sort of waited. You had a chance for a cooling off period. I think that's a big difference between like second and third. We talked about sort of the heat of the moment, and you just acted would be second. But if you like acted, reloaded your gun, and shot again.
That's first.
That's first. Because you had that intent can be like formed in a moment. So I think those are good examples of that. And to kind of talk about what we're talking on the weekly wine, in the Tyre Nichols case, those officers have been charged with second degree, not first degree.
That's correct. So they have been charged above the line.
Right.
Think about, oh, hi, sweetheart. Oh. My little dog is stuffing her nose under my arm. So cute. If you can see it on the video, it's worth watching. But so it's above the line where they intended to do it, right? That's the idea. But they're claiming it wasn't, so to speak, the premeditated.
Right.
However, Tennessee gets tricky, and I think that's worth heading to right now.
Felony murder.
Similar,
because
in Tennessee, so this is where we say these are the general rules, but you have to look to your states. In Tennessee, I love this because I'm not a criminal attorney. I'm not in Tennessee. I'm not a Tennessee attorney at all. I'm in Maryland, D.C., and Virginia. But reading the code sections is very interesting. So I've pulled out the code sections. So for Tennessee, the officers have been charged in killing Tyre in second-degree murder. And in the ericjbirch.com site, who's an attorney in Tennessee, he describes second-degree murder basically as this. So he says, in Tennessee, second-degree murder is the knowing killing of another person. So that puts us above the line, right? That it's knowing. And then he says the key difference with second-degree murder is mental state. A defendant does not intend after reflection to kill the victim. However, he might know that his conduct very well could have had that effect. For example, a defendant might beat a person to death and should know that several blows to the head could result in death, even if this is not the intended result. So that is classic second-degree murder, according to this site in Tennessee. That's his example of someone beating someone, and you should know that by hitting them in the head,
right,
that could cause death. And based on what we're seeing in the Tyre Nichols case, that's basically what they did.
Right. And I think what's interesting is the words after reflection, right? Because that's what the difference is that for it to be a second degree, there can't be this moment of reflection where you continue. I mean, I would think that sort of the space to reflect on something and then continuing to do it like moves us up that flow chart.
Right. It does. It moves us up. And here's my favorite portion though, that in talking about the goodness, I can't move as much because my little dog is on
so
me.
Sweet.
I don't want to move my dog. Isn't that awful? Where you get into this place as a dog owner or a cat owner that you don't want to move if they're lying on you. So I don't want to move my little arm because she's lying on it. But I've moved enough to say I've found the Tennessee code section, and the interesting part of this case for Tyre Nichols in looking at the homicide charges is, according to the description used and the example used by this attorney on the website, and that's probably a pretty classic description, is in Tennessee, first-degree murder is also described, so we're going higher, and that's described as a premeditated and intentional killing. So that's the classic version, right?
Yeah, absolutely.
There's your premeditated murder.
Yes. But
it's also described as an or. Okay, so they give you three options. One is clearly not applicable here. It's killing as a result of throwing or using a bomb, essentially. Right. But the second one has a whole list of things, and it says first-degree murder is, and here's number 2, a killing of another committed in the perpetration of or attempt to perpetrate any. And then it has a list of crimes.
Which, to me, automatically sounds like something called felony murder, not first-degree murder. Right?
Yes. Pause that.
Yes.
Because, we're going to do that. We're going to come right back to that. Yes. So the way that it's described immediately sounds like a term that we use in law school called felony murder that is used in a lot of states. I did not look it up for Tennessee, but I do know the basic rule in Virginia. And in Virginia, this is more like felony murder.
Right.
Where it's, okay, I'm pausing myself. I said you pause and then I'm talking about it.
We'll come back to it.
Okay. So going back to the Tennessee rule, so the list of crimes includes, it's a killing of another committed in the perpetration or attempt to perpetrate any ... kidnapping. Okay. Mm-hmm. In Tyre's case, we have a kidnapping.
That's what they're charged with it. Aggravated kidnapping.
Aggravated kidnapping.
Yes.
And the aggravated kidnapping is basically restraining someone, keeping them restrained against their will, keeping them imprisoned, so to speak, against their will, unlawfully. Yes. And the aggravation part,
the weapon.
Yeah, is either threat of force, use of force with a weapon, or actual bodily injury.
Yes.
So in Tyre's case, we have all three.
Right. So in my mind, if they're able to prove the kidnapping charge, does that not by its definition mean they fall into this category, right?
It seems like it.
That's what I'm not tracking. And maybe it's one of those things that it's not always about what happens, about what you can prove. And I understand that. Which actually we might come back to that saying, because that comes from a fun movie that we can talk about. It's like a 90s movie. We'll come back to that.
I like 90s movies. I grew up in the 90s.
It's so good.
Which one?
Called Eye for an Eye.
Oh, I don't know that one.
And
Eric probably does, though.
Probably, but it has this concept, and there's a crime. We can talk about it later, but the detective says to the woman who her family was affected by the crime, and he said, it's not always about what happened. It's about what you can prove.
It's true.
So with each level, as you go up this chart, there's more elements that are more difficult to prove, right?
Right. There's one extra thing you have to prove.
Exactly.
So in order to prove first degree murder, you don't necessarily you don't just have to prove it was intentional. You have to prove it was premeditated. Right. Or you have to prove in Tennessee's case that it was in the commission of another crime. In Virginia, and of course I left here we go. In Virginia, where I prosecuted the first and second degree murder, so the murder for first degree is, let's see, I'm going to try to read it off. Murder other than aggravated murder by poison. Lying, I like Virginia's because it's like you list out these specific things by poison. Okay, that's a first degree murder just because it's poison.
Arsenic in a lemonade, right?
Like, isn't that by itself kind of premeditation?
You would think so. Like, how do you accidentally or unintentionally poison someone? I don't know.
Yeah, so I think it's almost, what's the right word? It almost doesn't need to be said by poison. Like if it's
kind of like
if you're doing a poisoning, it's pretty much premeditated.
You would think so.
It's like synonymous. So why they felt the need to put poison in here?
Virginia has some funky things happening in their statute.
They do. They really do. So it's murder by poison, lying in wait, imprisonment, starving, or by any willful, deliberate, or premeditated killing, or in the commission of. And this is it's very similar to Tennessee's rule, or in the commission of or attempt to commit. And then this has specific ones too: arson,
right,
rape, forcible sodomy, robbery, burglary. So that's first degree.
That makes sense.
What you're looking at here is the idea behind it.
Extra punishment for people who do this.
Yeah, it's extra punishment of these are such awful murders.
Right.
Not like any murder is good or nice. So, I mean, a murder is a murder. It's
a loss of death.
But it's all the ones like that are scary.
Right.
Right. These are the ones you watch shows about.
Those are the headlines.
These are the serial killer type of crimes. Yes. These are the horrific child abuse types of crimes, where they're making those ones that just feel in your gut a little scarier, harsher, deadlier, hurter.
Yeah.
Physically.
Right.
More painful.
Which makes sense.
These are the first degree. And then second degree is so funny for Virginia. It's like, if it's not first degree, it's second. So it's all murder other than aggravated murder, and murder in the first degree is murder in the second degree.
Well, so there we go.
There it is. That's Virginia's. But both of them do have a felony murder idea behind them. Virginia, not as much as Tennessee, but tell us what the felony murder is, at least in general terms, because it's not one of the four.
No. So this is sort of an add-on. I would say, and that's kind of how we learned it, that of course the statutes, as we keep saying, are going to vary a little bit state by state, but the thought behind it is that you are committing some felony. So I like to think about, your grand theft auto, robbery, something like that, generally. And in the process of that, someone dies, and then you can then be charged with that murder. It's like, but for you robbing this place, or but for you stealing this car, this murder would not or this death would not have occurred. And it has been used in some funky ways. The one that I will never forget this. It just stands out to me so much learning it in law school. Brief facts where it was children, like a group of kids. I think they were ranged from like age 12 to like maybe 16. Anyways, it's not like super important. Attempted to break in and rob a place. But it was either a shop owner or a home, I really can't remember, was there and had a gun and chased them out and then shot them. And unfortunately, one of the children died. But the three
One of the robbers,
right. They're kids, but they're robbers. So one of the robbers died because they were shot by the person they were trying to rob. But all of the other robbers, the three other children, were charged under felony murder because in the commission of a felony, someone died. They didn't have any sort of hand. They didn't have a gun. They weren't hand in the death, but they were able to be charged with murder under this doctrine. I think I explained that.
Yeah, I think you did. And that's the thing, it's while in a commission of a felony. Right. So it's the idea of an expectation. If you do something by its nature that's violent, that you should expect somebody could die.
Right.
How many drugstores, banks, 7-Elevens, like gas stations are robbed? And the idea is it's usually by force.
Right.
It's usually with a weapon. So the idea is if you're carrying a weapon around, if you're demanding money through a weapon, somebody is likely to die.
Right.
Or get injured. And so it places that extra, if someone's around and dies, then it's felony murder. Now, in the Tennessee and Virginia statutes, it takes it to that extra level. It's if you're doing... So I'm going to use your example and alter it. Okay, perfect. Just a little. So I'm going to use your example to say that makes sense for felony murder is it's anyone who died while you were committing a felony. Okay.
Exactly.
So that is, it wasn't the shop owner who died.
It's very broad.
It's one of their own died. Mm-hmm. So it's felony murder.
Yes.
Now, the shop owner dies. Which one is it?
I feel like that, it could be felony murder, but you wouldn't charge that. I think.
Does that fit under first degree murder?
I feel like it could. I feel like you could make a case for it, right? I think this is the thing with the law. I do think you can make a case for first degree. Mm-hmm. I think you're more likely to succeed on a second degree, at least for whoever's carrying a weapon.
It depends. Yeah. It depends on if it's I think it depends on a couple things. So first of all, by the way that the statutes read, it sounds like if you're committing a robbery and you shoot someone, right, then it could be first degree.
Yes. Murder. Yeah, exactly.
If someone just dies who's not someone you shoot, then it's felony murder because it's so risky that while you're in the commission of this risky felonies, shocking somebody. It may not be the person you expected or, someone died and you didn't mean for anyone to die, but your behavior is so crazy, somebody's likely to die.
Right.
But it's easier in my mind to think of it switching over to a first-degree murder under these statutes if you're doing a robbery, you take the people to the back and you shoot them in the freezer or in the closet and then you leave. That seems to be during the commission of a robbery that would put it up to the first-degree murder level.
Yes, I think that makes a lot of sense to me, is like the difference between, okay, you're someone who robs homes or whatever. So you go in during the day when you think no one is there is a very different, it's not very different, but it's sort of in my mind, that person is not as scary than the person who breaks in when they know people are home at night, right? Like that is a very different type of criminal mind that we're talking about, at least in my perspective. And I think sort of all of these laws are, based off of legislatures that think like, how do we assess risk for a community and what do we make our laws look like to best do that?
Right.
And I think that makes sense to me, right?
Yeah, and that's, so in using your information, so in Virginia, it's lying in wait, imprisonment, starving, commission of arson, rape, robbery. Now it says burglary. Okay.
Oh gosh, now we're going back.
So it does include burglary, but burglary is a forcible entry.
Yes.
Each fact is different. Tennessee, I'm going to go back to Tennessee's.
Look at his little foot.
Oh, his little foot. Okay, so Charlie's over by Chelsey, and he's kind of on his, I guess he is on his side, and one of his little feet just went up onto her leg. That's really cute. He's very comfortable.
He's so sweet.
So Tennessee is very similar. Arson, rape, robbery, burglary.
Right.
Theirs is this is just, they have that kidnapping. That it just seems that there might be, and maybe this is the part I don't know about Tennessee, is would you be able to say, yes, but there are exceptions under the Tennessee laws that they aren't usually, but under the code itself, you seem to be able to make,
I think you could probably, again, it's one of those things, you could probably make an argument for all of it. But it's like, what are you most likely to prevail on, maybe?
Yeah.
I think that can be confusing as someone who does listen and watch a lot of true crime. I think that law school has given me a different perspective on that, of sometimes, again, I'm like, I said it before, like a little vengeful, like, throw them up. But I think law school has given me the ability to, even when I'm like listening to these stories, to be like, well, yes, but, right?
Yeah.
That you want to present your best argument, and sometimes sort of maybe reaching up is not going to allow you to present the most convincing case.
And that's very true. But you can also get into the idea of charging them with the highest.
And lesser included.
And as long as it's a lesser included, then one of them will stick. Or you hope
Which is a crazy thought to me, again, pre-law school. Like, I would, even understanding, it's kind of a strange concept to think of, like, kind of charge high, and that maybe the jury says, well, they did something, but not that, so we're going to convict them lower.
But it's only because it's not the action that's changed, it's the mental state.
Right.
That's the different level of proof. So they would put up, for Tyre Nichols, they would put up the same facts.
Yeah.
And then you would ask, do the facts fit under this mental state or that mental state?
Right.
And in Tennessee, here's the difference for me, which makes it seem like it's a little easier to prove first-degree murder with their actions, because there's this little section B that they have that Virginia does not have, that says no culpable mental state is required for conviction.
Which is
under
wild.
These sections.
Wild for a first-degree murder to say that.
Except the intent to commit the enumerated offenses.
So they're saying that if you had the criminal intent to commit kidnapping, you can impute that into the intent needed for first-degree murder.
Yes.
Which is wild. That is so wild.
That's where the felony murder rule is normally done. That's why there's that felony murder, which says, okay, you intended to rob, but you didn't intend to kill.
Right.
So we're going to get you under the felony murder statute, whereas that one in Tennessee seems to say all you had to intend to do is commit the other offense, and then someone died, and now you're guilty of first degree.
Right. Which is wild.
It is. But they're there for a reason.
Yes.
And in Tennessee, that's what it takes. That's what their legislature decided should be included. But it's, that's where we get into the intent is different. Now in Virginia, going back to you charged with the highest, so you could charge with first degree murder. If we were trying Tyre Nichols police officers who killed him, you could start with first degree.
Right.
And then you say, okay, first degree is,
all
just
of these
like
elements.
It says. It's by willful, deliberate, and premeditated killing. Okay? That's murder in the first degree. All other, that's not first degree, is second degree. So I say, I believe that I've proved that this was willful, deliberate, and premeditated. Or that it was in the commission of an abduction. Okay, that's how I say it. But
the jury can say,
the jury can say
I believe it was willful, it was deliberate, but I don't think you proved to me that it was premeditated. So we're coming back with second degree.
Yeah.
Right?
Because it's not the first, then it's second. It says everything else is second. But then I would have to go, if I believed it was not that, then I would go below that to voluntary manslaughter.
Right.
And it's just a little bit more. So it's not quite the same. It's not willful and intentional. Yeah. Okay, so then we say, well, it's still murder.
Yes.
But now my intent is less. I still did not mean to kill him. Or I did mean to kill him. Now I didn't mean to, but my actions did cause his death.
Yes.
So that's the difference. I will never forget, though, there was a trial while I was in Newport News, Virginia, and it was of a kid who shot another person, and the other two kids, essentially young kids, he lived.
Okay.
But he was severely injured. And they had charged him with malicious wounding. And the malicious wounding was with malice. Okay. So there you're getting into kind of like the first and second degree murder. It was done with malice. The unlawful wounding is you seriously injured someone and meant to.
Yeah.
But it wasn't with malice.
Right.
Okay. And then, so that was a lesser included of malicious wounding. So malicious wounding is you seriously harm someone and you meant to.
Right.
With malice.
Right.
Then you say take away with malice and it's you seriously harm someone intentionally.
Right.
Then you take away the serious harm and you call it assault and battery. Okay, so it's so then you get into a misdemeanor, all right? Now you're out of felony world and you get into a misdemeanor that it's just the intentional touching of someone else, okay? You intended to touch. Not necessarily that you intended to harm, okay? But that you intended to touch someone. I will never forget. So she charged him with malicious wounding.
Okay.
Indictment was for malicious wounding. And she went in and said, it's malicious wounding. Defense attorney stood up and says, no, it wasn't with malice. So it's at least just unlawful.
Right.
But we actually think it's assault and battery. And I almost laughed. I'm like, no, I can't laugh. It's a jury. I was in the audience. I wasn't even like prosecuting.
You're just watching.
I'm just watching. And I will never forget that the jury came back and found the guy guilty of assault and battery.
Wow.
For a shooting that seriously physically injured somebody.
Wow.
And they found him guilty of assault and battery. And I walked out going, what? Because it tapped him? Right? The bullet just touched him?
That is wild.
How is this? Yes, it was that upsetting, Willow.
She's
it was.
So concerned.
Yes, I'm sorry. Mommy's getting very upset.
That
was
is wild.
I just like, how do you do this? I was like, clearly it was malicious wounding. You don't just not shoot. I mean, the gun didn't just go off. He was sitting behind
We've
him
said
in
it
a
before.
car.
Guns don't just go off. How do you shoot someone without maliciousness?
Right, without malice.
That's the word. Not maliciousness.
But it was amazing that the guy didn't die, because otherwise it would have been a murder.
Right.
So that would have been one of the ones of, okay, well, you charge first or second degree, and then maybe it's manslaughter.
Right.
But it would be like coming back and saying, no, it was assault and battery.
It's wild.
What? Because you only intended to touch him with your gun.
That's interesting.
What do you do when you point and shoot a gun? What is the only intent you can have in my mind is to kill.
That would be my thought too. I mean, isn't that like the number 2 rule of gun safety? Like, don't treat every gun as if it's loaded is number 1. And number 2 is don't point your gun at anything you're not willing to kill.
Yes. Unless you intend to use it.
Right? Like, I'm not a big gun buff, but I'm pretty sure those are like rule 1 and 2.
Yeah, they are. That's what it is. So if you're pointing your gun at someone and you pull the trigger, what else do you think is going to happen?
That's fascinating.
Yeah, so that's how in my mind is, to me, that's why if you think that you have enough evidence to, now you can't just charge them with the highest crime all the time. You have to charge them with good faith, okay, that the evidence you have could prove first degree. Okay,
I'm so glad you said that, because I kind of want to talk about this a little bit. To me, that might be the harder thing in my mind, looking at this, is like, how do you prove someone's mental state, which is a question for a lot of crimes that I have. And I think it's something that in law school is interesting to learn about, of like, what evidence do you present? And like, obviously the classic examples are like, okay, a serial killer went and bought rope and tarp. Like, there you go. That is evidence of the mental state of premeditation, right?
It is. It's good evidence. Is what kind of planning was made. There's the guy who's charged with killing his wife right now.
Yes. The Google searches.
Right? He did Google searches. Now, I don't know if it was before or after she died. Do you know?
It seems to be after. A lot of the Google searches were of how long it takes before a body starts to smell.
Yeah. How do you dismember a body kind of searches. That at least seems to be pre-planning for disposing of a body. But do you do Google searches of drowning people?
Right.
Like how to get away with murder.
Right. Where do I buy a gun near me? How do I take the serial numbers off of a gun?
Right. Yeah, and a lot of the true crime podcasts and stories, I watch a lot of Forensic Files.
I love it.
God, I grew up on that stuff. And they came out recently with
it's like 48 hours.
Yeah, all of those is like you go back, is how far back did they start thinking about this? Yes. Were they trying to find a hitman? Yes. Were they trying to...
Pro tip. If you are buying a hitman online, it is a cop. Like, it is 1,000% a cop. You cannot hire a hitman online.
Yeah.
But people try to.
People do, because so
I'll tell you, this is the fun story. Well, I told you we'd come back to it, the 90s movie. Okay?
Yes.
And I don't know actors' names. It's a real big flaw of mine, but they're like famous actors, and I can see their faces. And the movie is called Eye for an Eye.
Okay.
And so again, it's a really interesting movie, because if you watch it with somebody, you like have these, sort of debates about the morality of the movie. So essentially the plot is that there's this beautiful family, happy, life is good. A man breaks in, sexually assaults and kills the daughter.
Okay.
Heartbreaking. There's some sort of technicality where evidence was excluded because someone didn't do something right and he gets off, right? Crucial. So as I said before, the detective tells, because the family is just beside themselves. How could this happen? And he's like, it's not about what happened. It's about what you can prove. Key point here in our story. Because as you can probably guess from the title, the mom hears that and really takes that to heart in her mind. And I love movies like this. I do love me some revenge movies, okay? So what does she do? It was fully premeditated murder. But she set it up because this guy, she knew who he was. She baited him into breaking into her house and she killed him, right? And the cop comes and he's like, be so for real right now. And she's like, prove it, right? Like, this is the movie. It's a very dramatic, cinematic thing, but it was very interesting to think. I was like, what is evidence of premeditation? So to throw that in, a fake story, some levity with some of these dark stories.
Oh, for sure. But that's the thing is what was done in the days, the weeks, the hours beforehand. Were zip ties bought? Did you buy duct tape? Did you, what did you buy ahead of time? How soon did you purchase the gun? Where did you get the arsenic?
I just keep it around,
Yeah, was it in the pantry? Was it down at the dollar store?
Right.
These are the things that you're looking at. But in the end, premeditation also, like you said earlier, doesn't necessarily happen in weeks in advance.
Right.
It can be, I decide to turn back.
Right.
And here's where I think you might have an idea for first degree murder for Tyre Nichols' case.
Absolutely.
Because let's forget about the kidnapping. Is it premeditated because Tyre got away?
In a period of reflection before they re-engaged.
And they ran after him.
That is the classic example of...
They went and grabbed him again.
Yeah.
And continued to beat him, if not worse. Harder and worse and more, because he got away.
Right.
So does that not, or it could be argued that goes straight to the after premeditation because they didn't have to come back a week later. All they had to do was some form of intent and decision to go and finish it off.
Right. We said that at sort of the top of the conversation of, okay, you burst in on your spouse and their lover. That's second. But you reload your gun, that then becomes first. That is not like a time period of planning, but it is the sort of a cooling off period or a time for reflection.
Yeah.
And if you have like a moment of that and then continue forward, I would make the argument, I think this seems very easy to put on a case for first degree murder to me.
At least arguable.
Look, me telling a prosecutor how to do their job before I graduate law school. Okay, I get it, but I'm also like,
but I'm saying the same thing.
Yeah.
At least it seems to me that there is a good faith argument to be had that the facts seem to say first degree.
And let him hash it out at trial. That's fine.
Let them argue it second degree, not first. But I think it's first.
And I don't even think
I would argue.
I don't even think that's a reach. There's some cases where I'm like, oh, I do really feel like that's a reach. This one, I really don't. By the statute, I don't think it's a reach.
Yeah, it doesn't seem to be. And so going to the voluntary and the involuntary, these are the harder ones where even we're struggling a little bit more to come up with the right kind of definitions. Hi, sweetheart. Yes, you can tuck in. That is so
sweet.
So voluntary manslaughter. So here's where we go, where the way Tennessee defines it.
Okay.
Is they're using that heat of passion.
There we go.
Okay, so here's the difference in some codes in some states. So in Tennessee, voluntary manslaughter is the intentional and knowing killing of a person in the state of passion due to adequate provocation.
Oh, this was a little fascinating thing to me I loved in first year crim. Adequate provocation, depending on what the state is, can be very, very different.
Yes.
Was this provocation for your average reasonable person? Mm-hmm. Other states take into account this particular person with their background. Does it equate to adequate provocation? And we might come back to that again, but that's one of my favorite. it's one of the most interesting things to me. There's the like famous case in New York of a man who
the subway.
That's exactly what I was thinking. There's a lot to that case, but
that case made me so angry.
I mean, this man kills. I think he shot a whole bunch.
6 kids.
I think it was
like 6 kids on the subway.
Shot 5 of them, if I remember, 5 or 6, and it was absurd. It was truly absurd. There's a lot to the case and a lot of undertones and racial connotations, but it did bring up this sort of conversation of, is the standard that we use, would a reasonable person have done this? Or this person with his background who had been attacked on the subway multiple times prior to this, what is the standard?
Yeah, the reasonable man standard versus the individual standard.
Yes.
It's hard to tell, and it's state by state, but yes.
Yeah. To me,
I guess until it happens to me, I want it to be a reasonable man standard, and then if I get caught with it, then I want it to be an individual to be standard.
Okay, yes, I think, and our professor did such a great job because she set it up just like because this subway case in New York, I mean, is atrocious. So everyone is so responding like that of like, this man shouldn't get the benefit of his back. Like everyone's mad, right? And I wish I remembered the name of it because, of course, as soon as we have that, the next case we get is like truly a heart-wrenching story of a woman who had been attacked and assaulted, and her kid was assaulted, and the guy broke back into the house and she killed him. And they're like, well, a reasonable person would have run out of the house. A reasonable person wouldn't have shot him, and none of evidence of her background, essentially, right? Oh, it's so hard because I don't know. The law is an imperfect thing, right?
It is. Yeah, it really is. And this is so interesting in Tennessee. So they've changed voluntary manslaughter to what the classic example seems to be of the passion murders.
Yeah.
But then their reckless homicide is when you recklessly kill someone.
Yeah.
So driving your car into a crowd of people or pulling, let's see.
Is that like racing down the highway?
Yeah, it would probably be the racing down a highway doing, I'm guessing that this would be something like the DUI.
Yeah.
But no, it looks like, okay, so Tennessee does have a voluntary, so that's the one we were talking about, in a state of passion produced by adequate provocation. Now, this one says reasonable person to act in an irrational manner. So that's that. And they have, they don't seem to have involuntary manslaughter. So they have criminally negligent homicide. That's how they've classified it.
Right.
Is the accused did something negligent, which in turn led to the death of another person.
Yeah.
Vehicular homicide is drunk driving, drag racing, poor choices in a construction zone, conduct creating a substantial risk of death. Then there's reckless homicide, which is basically anything
else.
Means thought without the consequences. So without thinking of the consequences. So there are those. In Virginia, do I have these? Of course, here I go. Everybody who's knowing me on these podcasts and everywhere else is my notes, my little rustle of notes. That's how I live my life. I think I might harm someone if I didn't have access to my notes. My notes were taken away.
They're so good. See, it's a good balance because I'm like, just the vibes. There was like this one.
I know, you and your vibes.
There was this one case this one time that was kind of like this. And Virginia could give me the citation.
Pull it out.
She could give me the blue book citation.
No. Well, see, it's my memory. My memory for specifics is not that good. I have a good general memory.
Yes.
And I've got a great memory for experiences. But once you start talking about is it says reasonable or not, or what code section was that, or what case name was that, forget it.
So I think case names I'm not great at, but I feel like I could tell you, and this is the wildest thing. Probably most of the cases we read in torts, like the big ones, I could tell you what happened in those cases and what the decisions were. Probably not any of the names of them.
Yeah, I can't even do that. That's why I take notes. I take really great notes, but I think it's because I learned that was the way I had to do it, so I would know it.
That makes a lot of sense.
And could return to it, where maybe I would know it in the moment, but I couldn't return to it. But I always had my notes, and if I had my notes, I could return. But now it's almost a crutch.
I think it's good, though.
I don't know.
I mean, I could not have told you any of what the statutes were.
Oh, clearly I couldn't without that. So we are all better informed because of my notes. Though it takes me a while to find them and read them. I need to come up with a better system for organizing them here. But that's basically, I'm trying to come up with another one or two small stories for these. For any of the difference in the homicides and murders. There's always this self-defense issue. And I think that's where the subway case comes in, is what are your defenses to the murders?
Right. Is that like a justifiable homicide, essentially, is when you're putting on this affirmative defense of saying, yes, I killed them.
I did.
But I did it in self-defense. Yes. You have to admit, yes, my actions caused their death. But it was because I had to. Yeah. And that's when you get into the really interesting state by state of like the castle doctrine and
standing your ground,
duty to retreat, like, which vary a lot.
They do. I think that's more the biggest differentiations in the states versus the homicide rules. They're fairly similar. Here's the top two. Here's the bottom two. There's at least that little top to bottom. Generally, one half above, one half below.
Absolutely.
But is how you apply the defenses and which ones you have, I think varies a little bit more.
And I'll throw this in because this is you're going to laugh because you know what case I'm about to talk about. I have been obsessed with this case for so long and with Wisconsin.
One? Oh, yes.
It's perfect.
Chelsey loves this case.
Because it is such a fascinating. So this is
we've been following it through her.
Oh, yes. Following it for years. This is a case where she has been charged with first-degree murder. And she is a woman now. She was charged when she was 17, so she was a girl at the time. She was charged with the murder of this man in his 30s who had been trafficking her since she was about like 14, 15. Wisconsin.
But was no longer trafficking her.
He was still having a sexual relationship with her at this point, and she was still a child. So she was still 17, and he was still in his 30s. So legally, not cool, not kosher.
Yeah.
So Wisconsin has this really interesting statute. And when you talk about just statutory language and construction, which normally is super boring, but this isn't. So as we as a country have like understood human trafficking, so sweet, and particularly sex trafficking more, many states have created an affirmative defense of asserting sex trafficking as a defense to being charged with usually solicitation, prostitution, sort of petty theft.
Yeah.
Wisconsin lawmakers said, you can just assert this for any crime. One sentence, period. So, gotta love a public defender's office because that's who took it all the way up to the Wisconsin Supreme Court.
Good for them.
They had her case. Her name is Crystal Kaiser. And they said she's asserting sex trafficking as a defense to her killing him, to murder. And then they were like, whoa, you can't do that.
But tell us the facts. I mean, a 2-minute version of the facts of this death.
So it is a very complicated case. I don't think it's disputed that he was trafficking her, that they were having a sexual relationship. He had taken her to hotels to kind of have sex with his friends.
But not then. She didn't kill him while they were in the hotel having sex with their friends.
Which is what makes it different than a normal self-defense. Mm-hmm. So in normal self-defense, you usually have to be in imminent danger. That's kind of the general.
Right, where if he traffics you, he gives you to the friend, you're supposed to have sex, you feel like your life is in danger.
In that moment.
You shoot.
Yes.
You kill.
This is different, though, because, like I said, this statutory construction, it just says can be asserted against all crimes, essentially, and it doesn't specify a need for imminent danger. When she shot him, they essentially seemed to be in his home. They had ordered pizza, had possibly been physically intimate. It's not really clear. And she shot him at point blank range in the head.
when he was not trying to hurt her.
So she's asserting that he was attempting to initiate some like physical, some sexual relationship, but not forcibly. It seems like that is sort of a big thing that's in dispute. But she shot him, she killed him, and she stole his car. So the facts just are what they are. But this went, and the reason this case has been delayed so long was there was an argument of like, is she allowed to assert sex trafficking as a defense to first-degree murder? It went all the way up like to the appellate court, to the Wisconsin Supreme Court, and it was this past June or July that they released a ruling allowing her to assert that defense. And so now trial has been scheduled, and we will see how that goes. Wow. But that varies a lot state to state. Like I said, that particular defense, some places requires a threat of imminent danger, imminent harm.
Right.
This one did not, which is wild. I mean,
it is.
In this case, like I have a lot of feelings about maybe people who have sex with children should be scared they'll get shot in the head, but like that's not how our justice system works.
Right. It's kind of the felony murder is yes. The idea is
I'm like, look, I think it's a social good. Maybe people like that should be scared, but that's not how our legal system works.
Instituting the purge.
Honest. Look. True, like
I cannot put you in the world. I cannot release you into the world. It's not imprisonment, everybody, when Chelsey's here. It's for everyone's own good.
Honestly, look. I went to law school only to be like the biggest fan of vigilante justice, right?
To be clear, here's our legal disclaimer.
Yes,
Thank you, Chelsey.
I'm not condoning any crimes. I'm just saying.
This isn't a good thing. We're not asking for, we're not supporting.
No, because there are a lot of problems with, as much as I like to joke and, say burn it down, exact your own justice. The reality is like there was a point in this country where that was allowed, and what it did was not great. We had lynchings, and that was just the reality of like what it looks like when
each person chooses their own idea of justice.
Exactly.
And the feeling, I support the feeling because that's where it comes from. Is it doesn't feel right. It doesn't feel justifiable. It doesn't feel like justice. Yeah. So something different more extreme should be done. And the feeling behind it is very real. And I can completely support that. But on the whole, and in total, not just on the whole, in total, we don't support taking the law into your own hands. No. We suggest and strongly advise, though not as your attorneys, but just standard moral advice. Please don't commit a crime.
Yes.
It really, don't commit crimes.
Don't Google things about
it really, and consult an attorney.
In your
We're
state.
Not your attorneys.
I'm not an attorney.
Attorneys. She is not an attorney. These are all our legal disclaimers.
Yes.
This show is for education and entertainment only. Hopefully a little education, but at least some entertainment.
I think we explained the levels of homicide fairly well.
I think so.
I think we gave an example for each to make it easy to remember.
Yeah. A little bit. Check out your own states.
Yeah. Talked a little bit about defenses.
Hit a few. We could maybe, we've got so many topics we can talk about.
Self-defense would be an interesting topic to cover on its own.
So interesting because it's not just to murder.
No. It's for so many things.
So many things. And I've got some good stories on self-defense.
I bet you
do. I do have some good stories.
We might have to. Look, I have a list of topics we're going to cover that are just my whims at this point, like self-defense, character evidence.
Yeah, we still got to come back to that one, but this one was because it was too timely with regard to the Tyre Nichols case, where it seemed to fit that this would be the week to do this, to get it back out into the public of here's kind of what you're looking at, why you're looking at, and then it basically goes down to the mental state of the person committing the crime.
Yeah.
That is how it's broken down. That's a lot of crime and how it's broken down.
Pretty much.
For levels of proof. But we will be following the Tyre Nichols case very closely. Yes. If you want to go back and hear more about that case in particular, and the crimes and charges for that, go back to the Legal Weekly Wine for... I'm losing track of the first week in February. So the first Friday in February. So February 3rd. We're in the first full week of February now of 2023. And for those of you who are listening,
January go?
I know. And yeah, I mean, this one is relevant no matter what year you're in, because it's about murder. But
I love it.
Anyway, that's how we feel about that.
Yes.
I'm Virginia Tehrani.
And I'm Chelsey Rogers.
And we are part of Tehrani Law, because you never need a lawyer
till you do.